judgment in the case of Tata Cellular, wherein the scope of judicial interference in matters pertaining to is very limited. Then we have further referred to various constitutional bench judgments which are specifically dealing with interference insofar as economic policy is concerned. The judgment in Prague Ice and Oil Mills versus Union of India rendered by 7 judges. Then R.K. Garg versus Union of India. Then Sri Sitaram Sugar Company versus Union. And which has been held that there has to be a great deal of restraint insofar as interference in the matters pertaining to economic policy is concerned. The court cannot substitute its judgment for that of the legislature or the executive. It does not supplant the feel of the experts with its own views. And we have also scrutinized the record. And after examining the record, we have found that the judicial decision-making process cannot be flawed merely because the procedure has emanated from the central government. We have construed that the term recommendation has to be construed in the context of the statutory scheme, and what is contemplated is a consultative process. And from the record, it appears that there was a consultation between the RBI and the central government over a last period of 6 months. Then, insofar as the fourth issue is concerned, we have considered the 4-pronged test held in modern dental education. One, as to whether the action was designated for a proper purpose. We find that the 3 purposes are proper purposes, and whether there was a reasonable nexus of the measure with the purpose sought to be achieved. And we have held that there was a reasonable nexus. Then, insofar as the third test with regard to alternate measures is concerned, there cannot be any alternate measures for the action which is thought to be done by demonetization. Then the fourth one is whether there was proper relation between the importance of the purpose to be achieved and the limitations on the constitutional rights. And applying all these 4 tests, we have held that the action cannot be hit by the doctrine of proportionality. Then issue number 5, with regard to reasonableness of period is concerned, we have considered that in the 1978 Act, the period provided was only 3 days, and which was extendable by a further period of 5 days. And this has been found to be a reasonable period in the case of Jayantilal Shah by the Constitutional Bench. In the present case, the period provided is 52 days, and therefore, applying the principles laid therein, it cannot be said to be an unreasonable period. Then, insofar as issue number 6 is concerned, we have held that the entire scheme of Section 3 and 4 has to be considered. The powers under the provision of subsection 2 of Section 4 cannot be construed in isolation, and therefore, the RBI does not have an independent power. Insofar as hardship is concerned, we have referred to the judgment in the case of R.K. Garg and Sonia Bhatia, and we have also considered that it is not relevant as to whether the objective thought has been achieved or not. So what is required is that there has to be an objective which is for the proper purposes, and there has to be a reasonable nexus with the measure and the object to be achieved. We also held that we cannot direct the central government to exercise its powers under subsection 2, and it is for the central government to exercise such a power if it finds that the exigency so arise. Accordingly, we have answered the reference as under 1. The power available to the central government under subsection 2 of section 26 of the RBI Act cannot be restricted to mean that it can be exercised only for one or some series of banknotes and not for all series of banknotes. The power can be exercised for all series of banknotes merely because on 2 earlier occasions the demonetization exercise was by plenary legislations. It cannot be held that such a power would not be available to the central government under subsection 2 of section 26 of the RBI Act. Then second, subsection 2 of section 26 of the RBI Act does not provide for excessive delegation inasmuch as there is an inbuilt safeguard that such a power has to be exercised on the recommendation of the central board. As such, subsection 2 of section 26 of the RBI Act is not liable to be struck down on the said ground. In 3, the MP notification dated 8 November 2016 does not suffer from any flaws in the decision-making process. 4. The MP notification dated 8 November 2016 satisfies the test of proportionality and as such cannot be struck down on the said ground. 5. The period provided for exchange of notes while the MP notification dated 8 November 2016 cannot be said to be unreasonable. And 6. The RBI does not possess independent power under subsection 2 of section 4 of the 2017 Act in isolation of the provisions of section 3 and 4(1) thereof to accept the demonetized notes beyond the period specified in notification issued under subsection 1, section 4 of the 2017 Act. Having answered the reference, we direct the registry to place the matter before the Honorable the Chief Justice of India for placing it before the appropriate benches. Needless to state that all other contentions are kept open to be considered by the benches before which the matter would be placed. Before parting with the judgment, we place on record our deep appreciation for the valuable assistance rendered by Sri R. Venkatramani, the Learned Attorney General, Sri P. Chidambaram, Sri Shyam Diwan, and Sri Jaideep Gupta, Learned Senior Counsel, and all other counsels appearing for the parties.
ഏറ്റവും പുതിയ വാർത്തകളും വിശേഷങ്ങളും അതിവേഗത്തിൽ അറിയാൻ Zee Malayalam News ആപ്പ് ഡൗൺലോഡ് ചെയ്യൂ, സന്ദർശിക്കൂ www.zeemalayalamnews.com.